Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jim Quillinan, who is an attorney and a shareholder with Hopkins Carley in San Jose, prominent law firm. And he is the chairman of the Family Wealth and Tax Planning Department in that firm. He's been practicing law since he graduated with his law degree from the University of Santa Clara in 1974, which, by the way, is the same time I graduated and started in public accounting. He is highly respected in the legal community and is a frequent lecturer and author for the State Bar of California and continuing education of the bar. He serves as special master and referee in Santa Clara County and San Mateo County Superior Courts relating to complex trust and probate matters. Now, on a more personal note, Jim loves to go to the movies, and his movie reviews are very popular, and you can sign up to receive them by email for free at www.hopkinscarley.com, and you'll be seeing that coming up on your screen from time to time during our interview. Another thing I learned today, I'm in very good company because Jim has been a guest with David Letterman. And so, gee, wow, that's pretty cool. So congratulations on that, Jim. And it's a pleasure having you on the show.
It's a pleasure to be here, Mike.
Okay, thanks so much for being with me. So today, Jim and I will be discussing the problems created by the repeal of the federal estate tax and the adoption of carryover basis for 2010 with the restoration of the estate tax starting in 2011. And before we get started, I want to caution our viewers that this is only an introduction to a very complex area, and this is to help you become aware of the issues for a further discussion with an attorney or other tax advisor who's familiar with this, if there is somebody that's familiar with this. The problems we are discussing are complex, and I guess I'll say there aren't even solutions to some of these problems that we know about. So anyway, so this is going to be an interesting area for us to talk about. So with that, Jim, let's get started with our questions.
Okay.
So let's sort of frame the problem. What is the problem with the federal estate tax rules for 2010?
Well, the problem is that during the early days of the Bush administration, when they started the quote repeal of the estate tax is repealed effective in 2010, but under sunset provisions, it magically reappears in 2011, and actually in a more onerous way than it was just last year in 2009, with the exemptions dropping from $3.5 million to $1 million per person.
Ouch.
And the rate going from 45% to 55% with even a possible 60% rate under certain circumstances. So next year the tax is going to be more onerous than it was just last year. And then the other issue with it is that under our law, for a very long period of time, when someone passes away, their assets get what's called a fresh start or step up in basis, such that if you have a home that you bought years ago here in Silicon Valley for $50,000 and it's now worth $1 million, your basis for income tax purposes goes to $1 million if it's sold.
Right.
Now with carryover basis, your basis stays the same at $50,000, with the exception if there is some special allocation rules that we can get into, where it would possibly get stepped up some. And the crazy thing is that I actually have this happened right now in the office. If my client had died in December, there'd be no tax at all. But because she died in January, there is no estate tax. But there's about a $500,000 capital gains tax on her home.
Ouch.
Because the family has to sell it. So these new basis rules are a problem. And then we have the historic problem of trying to determine what someone's basis is on an asset they may have been holding for years and years and years. And so it is a significant problem. The other really big issue in all of this, and this is the part that's driving us crazy as estate planners, is that the bills that Congress has been looking at, some of them are retroactive to January 1st, 2010. There's a question of whether that's constitutional or not, or whether they're going to do it or not. And so we're in a situation where officially we have no federal estate tax. Officially we have carryover basis, but it may all get unraveled on us overnight by legislation. There's also the possibility that Congress will do nothing, and we'll have this 1 year with no estate tax, carryover basis. Then next year we'll have low exemptions, but we will have step up in basis and higher rates. So in terms of doing planning, it's extremely difficult to address all of those seemingly, who knows, problems, and it's just because of Congress inaction. Mm-hmm. The other issue that's driving us crazy is that theoretically, because of this basis issue, we're supposed to be filing a new form this year. It's called a Form 1022. The only problem is the IRS hasn't promulgated it yet and doesn't look like they may. That form would technically have to be filed 9 months from the date of death. So if you had a January death, you'd be looking at September rather, filing time. So it is a problem. So we just don't know where it's all going. One of the things that's held up all the legislation is the health care bill. Yes. Everything was focused on health care for the last, 4 or 5 months minimum. And that is now over.
Yes.
And Congress is in recess right now. They're not coming back till next week. And so we expect something's going to happen. There are bills in both the Senate and the House to reinstate the federal estate tax prospectively, retroactively, with bigger exemptions, lower exemptions, higher rates, lower rates. There's a lot of who knows what's going to happen. There's even an optional bill that'll give you the choice of treating it retroactively or treating it as if there was no tax this year. So you can work under the existing law, or you can use a retroactively applied law. Yeah. So we don't know.
It's enough to drive you crazy.
Absolutely.
There's another thing that we haven't talked about yet. And it's an issue really that probably a lot of people aren't even aware of, and that is that we have this thing called the generation skipping tax. So maybe we ought to just sort of throw that into the pool here.
Okay. Well, just a quick explanation with the generation skipping tax is, it generally what it's trying to do is to stop people from leaving property in trust for their children for the children's life, and then have it go to the grandchildren, estate tax free. And there's an exemption in there, so you can do it within certain parameters, but that's been repealed right now too. So we don't have an estate tax, or we don't have an estate tax, and we do not have a generation skipping tax. And the generation skipping tax, when it applied, was an additional 45%. Right. So you'd pay the 45% estate tax, and you'd pay another 45% on anything that was a generation skipping. So we were always very careful to allocate generation skipping exemption, creating what we called exempt and non-exempt shares. But probably the single biggest issue that we've run into is that it was quite common for wealthier clients to say in their trusts and wills, I leave to my grandchildren the maximum amount I can leave them for generation skipping transfer tax purposes. Well, in 2009, that was $3.5 million. Mm-hmm. In 2010, that's infinity.
Yes.
And so if you have a gift off the top to your grandchildren that's using that formula language, right now you have the potential of having your entire estate go to your grandchildren. Yeah. And that may not be what you intended. So that's a problem. Yeah. And this is one of the things we're trying to address with our clients. And there's ways to fix it, obviously. But we're not, to go and make all those changes when come next year, that's exactly what you would want. Yes. We're just in this conundrum. We don't know exactly what